I know we've got a lot of content to cover, so I don't want to shortchange the presentation. So we just have a few housekeeping things as folks are still continuing to join us. But good afternoon, everybody. Welcome to our Lunch and Learn, an election year update on California's new governance and ethics laws. My name is Melissa Keene. I'm a senior program manager with the Institute for Local Government, and I'll be your host and moderator of this afternoon's webinar. Just a quick overview, since we're in a kind of a short format, we're just going to do a quick welcome and some introductions of our panelists. And then we're going to spend the bulk of the hour talking about an overview and updates on the Levine Act and what implications that has for this year as we go into our next election cycle. We'll have some time for audience Q&A, and then we will wrap up and adjourn by 1 o'clock. Some quick housekeeping items here. You probably noticed that you're on mute. We will be keeping you on mute just because of the size of the audience for today's webinar, but we obviously accept questions at any point in time. So feel free to drop any questions into the Q&A box that you see on your screen. We'll be monitoring that, responding to logistical questions as we go, and then pulling the substantive questions that you all have into a queue that we will get through as many as we can when we get to that portion of today's webinar. We also, as you probably noticed when you jumped on or when we started the recording, that we are recording today's webinar, and we will be posting that. It will be available shortly after today's webinar, likely by early next week at the latest. So before we jump in, just want to share a little bit of context and information about ILG in case you aren't super familiar with us. We are a statewide nonprofit that's affiliated with the League of California Cities, the California State Association of Counties, and the California Special Districts Association. So our job, our mission is to really help you all do your jobs at the local level. We provide practical and easy to use resources so that you all can effectively implement policies on the ground. We do that through training like this and conference sessions or in-person trainings. We provide technical assistance. We provide resources online, capacity building and convening services for you all in a number of areas. So today's webinar is connected to what we call leadership and governance, which is some of the state mandated trainings that you will have to comply with, as well as information and resources on how to navigate the changing legal requirements and boundaries that govern how you all as local agencies operate. In addition to that space, we also work in public engagement, workforce and civics education, and sustainable and resilient communities. And we provide resources and training on all of those different topics throughout the year. So if you aren't connected with us, definitely check out our website, sign up for our newsletter, and you can access information on all of those topics and hear more about upcoming resources that are being released and trainings that we'll be hosting. So with that, I will go ahead and turn it over to our presenters this afternoon. So I'm joined by Nick Norvell and Holland Stewart, who are both partners with ILG partner, Best and Krieger. Nick and Holland.
Good afternoon. Thanks, Melissa, and thank you everybody for joining us for this important and timely topic. I'm Nick Norvell, a partner in BBK Special Districts and Municipal Law Practice Groups, and co-chair of the firm's Open Government Ethics Working Group.
Good morning, everybody. Thanks for joining. My name is Holland Stewart. Melissa actually, I think, inadvertently gave me a promotion. I am an associate with the firm, and I'm in the Environmental and Natural Resources Practice Group. Nick and I do a lot of the same stuff. We serve as general counsel to water districts, wastewater, some utilities. And so we spend a lot of our time with Brown Act and with, conflict of interest stuff and helping local agencies in their day-to-day duties. We're for good governance and this is just a part of it. So we really appreciate you guys joining and in learning about this important and very timely topic, especially in an election year. Next slide, please. So today, I'm going to take the first half and then Nick is going to take the second half. Today, we're going to go over what is, I think, surely the biggest change to sort of campaign finance laws, certainly in recent memory, is the Levine Act and SB 1439, which was passed in 2022, and we'll get into that. We're going to drill down deeper into the Levine Act and the changes in sort of how they apply to local agencies. And then Nick is going to take it from there and talk about new FPPC regulations and sort of best practices for local agencies, and things that you can do, you know, to make sure that you're complying with the law and doing the best that you can. Okay, next slide, please. So let's give a little bit of background here. I think that'd be helpful. So in 1974, the California voters passed Proposition 9, which is also known as the Political Reform Act, and it was a response to Watergate, and sort of a general societal unease about political corruption and a way to get money out of politics and sort of, you know, make it fair and transparent for everybody. In 1982, then the California legislature passed the Levine Act, which became part of the PRA. But unless you served as an appointed member of a public body like a LAFCO or a Joint Powers Authority, you may not have heard of it until recently. The Levine Act was enacted after the LA Times published an investigative report that members of the California Coastal Commission were engaging in sort of a pay-for-play scheme involving entitlements and permits for development along the California coast. So the Levine Act aimed to prevent such practices. However, it only applied to appointed members of public bodies who are running for a different elected office, such as school boards, city councils, special districts. And so if you were just an elected official directly elected by the voters, such as a school board member, a councilman, or something like that, it did not apply to you until 2022, when the legislature passed SB 1439, which, among other things, extended the Levine Act's reach to officials directly elected by the voters. So now elected positions are treated the same as appointed ones. Next slide, please. So what does the Levine Act do? The Levine Act's fundamental rule is that an agency's officer is prohibited from accepting, soliciting, or directing campaign contributions over $250 from any party to or participant in a proceeding involving a license, permit, contract, or entitlement for use for their agency. So there's a lot of big words there, and a lot of what we're going to talk about today is how those words are defined and implemented and what your analysis should be if you are an elected or maybe an attorney representing a local body. So I want to highlight for you officer, the number 250 in terms of how that's calculated, party to, participant in, and proceeding. We're going to get down into the details of those in a bit, but I want to highlight those for you as those will often be, I think, part of your analysis and maybe the most important part. So the Levine Act's prohibition on campaign contributions over $250 applies while the proceeding is pending before the agency and for 12 months following a final decision. One thing to note here, an officer must know or have reason to know that the party or participant has a financial interest in the proceeding. However, and the officer has no affirmative duty to look into or do research on whether the party or participant has a financial interest. You must either know or have reason to know. Okay. Let's go to the next slide, please. Thank you. So if an officer receives a campaign contribution of more than $250 from a party or a participant or their agent, in the preceding 12 months, they may be disqualified from participating in the proceeding. So meaning that you have to recuse yourself from voting on whatever contract or entitlement or whatever is before the agency at the time. The officer's recusal depends on whether they knowingly and willfully accepted the contribution, or even just that they accepted the contribution knowing that the donor had a financial interest in the proceeding. So getting back to that pay for play thing that the Levine Act is meant to address, that this now applies to our local bodies that have members directly elected by the voters. So if an officer receives more than $250 from a party or participant or their agents, and they knowingly and within 12 months, and they knowingly and willfully accepted the contribution, or just that they knew that the donor had a financial interest in the proceeding, the officer must disclose the contribution on the record and recuse from the proceeding as a whole. Now there are ways to cure and potentially also, to basically have to send the money back. I'll get to that in a second. within a certain amount of time, and then you can participate in the proceeding. But as a general rule of thumb, you must recuse. So if the officer did not knowingly and willfully accept the contribution, and they did not know that the donor had a financial interest in the proceeding, the officer must still disclose the contribution on the record, but they are not required to recuse by law. Although obviously you may recuse if you wish, and sometimes, at least in our opinion, it would be wise to do so given sort of the optics and general ethics principles. So moreover, parties to and participants in a proceeding must disclose on the record any contributions to officers in excess of $250 within the prior 12 months, and they are prohibited from making contributions to those officers for another 12 months after the final decision. So if you are coming with a contract or a permit or a license or something to a city or to a district, and you have donated more than $250 to one or more of the officers, you must disclose that on the record, or you also could be in violation of the Levine Act. So if you have violated, the chat, we will get to these in a minute, but I'm going to close it because I'm getting distracted. I'm not great at multitasking. So if you have accepted campaign contributions in excess of $250 while a case is pending before your agency, right? So this is pre-final decision. There's one set of rules. If an officer accepts a contribution that would otherwise require them to recuse, they may still participate if they return the money within 30 days from the time that they knew of both the contribution and the proceeding, right? So I think that what this does in a practical sense is that you have to really keep track of who's donating to your campaign and of what's coming before your agency, right? What's within your agency's jurisdiction. And then this is the last thing, and on this, and then we'll move on. If you receive a campaign contribution over $250 from a party or participant after a decision has been rendered in a proceeding, such as a contract or entitlement or something like that, and you accept a contribution over $200 or $250 for up to a year after that final decision, you may cure this violation of the Levine Act by returning the portion that exceeds $250. So, for example, if you receive $500, you have to return at least $250, right? But you can only if you did not knowingly or willfully accept the money, right? So if it's just donated to you, you may just return it within 14 days and say, I didn't know, wasn't trying to violate the act, and that's okay per the FPPC's regulations. Next slide, please.
Holland, before we move on, we have a request for you to repeat the definition of an officer. Can you share that before we keep going?
Oh, sure. I'm going to get there in a couple of slides, but I can do it now. And thank you, Mr. Brown. I see that probably would be helpful. So an officer now, after SB 1439, is defined. So that is the law that was signed 2 years ago and then went into effect January 1 of 2023. Is in any elected or appointed officer of an agency, any alternate to an elected or appointed officer of an agency, and any candidate for an elected office in an agency. So, a sitting board member, or council person, or board of supervisor serving in that role, as well as somebody that's in an appointed position, like on a LAFCO, would be, or a Joint Powers Authority would be considered an officer. And it's actually it's an even broader definition than just that. And I'll get into it in a couple of slides.
Perfect. Thank you so much.
Thank you. Okay, let's go to slide 8, please. Thank you. We'll get to these questions. Thanks, guys. It's great. So this is where it gets kind of interesting, right? So the Levine Act only applies to certain types of proceedings, meaning that, it's something for your agency, your city, your county, your special district to consider. Something is before the board or the council for determination. And so to be considered a proceeding under the Levine Act, where the act would apply, it's any meeting where an agency body decides whether to grant, deny, revoke, restrict, or modify a license, permit, or other entitlement for use. Now, entitlement for use is a little bit clunky as a legal term. So I've kind of written down just a general rule of thumb that I think would be a good, for our agencies and our chief executives to sort of consider as they think about this stuff, right? So while there are several notable exceptions to this requirement, such as competitively bid contracts, personal employment contracts, or some sort of general policy decision, right? Enacting or like you're adopting maybe an invocation policy, so something of that nature, where it applies generally to all or most people. A good rule of thumb to follow for your Levine Act analysis is if it involves a determination by your agency of whether someone or a specific group of people get something from you, such as a contract, permit, license, franchise, etc., the Levine Act probably applies. And even if it doesn't apply, it's best to do the analysis to determine that it doesn't. Then have to kind of go back and see if you can cure, and that, and try to figure it out on the back end. And under the Levine Act, a proceeding is considered pending before your agency when it is either before the agency for consideration, meaning that it is on the agenda or an application has been submitted, to your city for, for maybe a conditional use permit or something of that nature, or when it is reasonably foreseeable that such a proceeding may come within your agency's jurisdiction, right? I mean, if you as the officer, or if you're an attorney, if you're advising your agency, if you know that something is kind of coming down the pike, the law does not excuse your compliance with this term just because it was not specifically filed or on the agenda for your consideration. It's much broader than that, and it kind of goes to what's reasonably foreseeable that is really coming down, to for determination by your agency. Next slide, please. Yeah, so here's some common examples. So we have land use actions relating to specific properties, as well as other licenses and permits, franchises, contracts. This includes most of your contracts, including professional services, development, real estate, etc. There are some exceptions, and these are very important, right? Just for the practical application of this, that you have competitively bid contracts are not subjected to this, to the Levine Act requirements, and then you have your labor, your employment stuff. So those are, highly, it's important to know, especially for cities, if you have a union for your employees. I mean, that those exceptions become very relevant for you, and counties too. So yeah, and then LAFCO actions, agency formation reorganizations, and then rules affecting the small industry with limited businesses. So that I think that rule of thumb, I think, carries us here as well. Next slide, please. Okay, so who does the Levine Act, so that's section 84308 of the government code, who does it apply to? So Mr. Brown, thank you for your question. We're going to get into it a little bit more in detail here. Next slide, please. Okay, so who is an officer under the Levine Act? So the government code defines an officer to include two categories. That's candidates for office and actual officers of the agency, a sitting board member, or planning commissioner, or a city council person, something of that nature. And then so the FPPC has expounded upon this definition in its regulations to further define it as an elected official, board and commission members. I think I saw a question about somebody about municipal commissioners. Yes, they would fall under this. Chief executives, and generally agency employees with decision-making authority in the proceeding who are candidates for office or have been candidates within the preceding 12 months. So a contribution under the Levine Act is just to a campaign. So somebody either has to be a sitting member of a board or be running for a board, and have, be able to accept or solicit or direct campaign contributions, on their behalf or somebody else's. So that is the definition of an officer. It's very broad. It's meant to be very broad. And so if you have questions about it, you should talk to your legal counsel. Or I would say probably just better safe than sorry. You should do your Levine Act analysis to figure out whether recusal or refunding the money is an appropriate next step. Next slide, please. So this is where, and I wish we had 5 hours to talk about this stuff, although for all of your sakes, it's probably best that we don't. It's very, very dense and very complicated in its applications. Sort of simple on its face, complicated in practice. It's like too many things in the legal world. That's just sort of where it is. So let's talk about who is a party. This is pretty simple. A party is any person or business who files an application for or is the subject of a proceeding involving a license, permit, or other entitlement for use. So this one's pretty easy, right? Somebody's name or a company's name is right there on the application. John Smith is applying for a conditional use permit. John Smith is a party. John Smith is obviously going to be subject to the requirements of the Levine Act. A participant is a little bit fuzzier of an analysis, and it's meant to be broad and it's meant to be a little bit squishy. So bear with me. So the Levine Act. Sorry, let me back up. A participant is defined by a person who is not a party, but actively supports or opposes a particular decision in a proceeding involving a license, permit, or other entitlement to use, and who has a financial interest in the decision. And what you're going to see in the examples later is that financial interest is broad. It's meant to be broad for a reason, but it's going to capture more than, at least when I was learning this stuff, more than I thought that it would have at that stage. So a participant must directly engage with the officer or agency staff to influence the proceeding to be classified as a participant. So this means that you have to show up. A participant shows up to a council meeting or a planning commission meeting to advocate for a conditional use permit or for a development or something of that nature, right? A participant could show up to a board meeting if you're a water district, and as the engineer that would be potentially hired, by this contractor to do something. So the engineer comes and says, hey, I want you to grant this contract to this contractor to put in a pipe. I'm the engineer and I'm going to benefit from that because I will get money and I will get, to work on this great project and have it benefit my business and myself. So that is important though, because that's a direct communication, right? Something like a letter to, to a board president or to staff or something like that. It's direct engagement with the agency to try to influence that decision-making. And indirect communications such as writing an op-ed, so to speak, in a paper in support of a development, that does not make somebody a participant, even if they have a financial interest in the eventual outcome of that proceeding. Next slide, please. So this is interesting, right? So the Levine Act also applies to the agents of whatever party or participant is trying to influence, or is just participating in the proceeding. So a party or participant may also act through an agent and fall under the scope of the Levine Act. A person is an agent of a party or participant if, one, they represent the party or participant for compensation, and two, appear before or communicate with the agency for the purpose of influencing the proceeding. And so this, I think is to sort of, I think if I'm remembering sort of the legislative history of this, there's some concern that, hey, well, we would be classified as a party or proceeding, and sort of subject our campaign contributions and our influence under the Levine Act. Let's send an agent to circumvent that. So the legislature and the FEBC have said, no, if someone is acting as an agent, and they fall into these categories, they are also going to be subject to the Levine Act requirements, and any campaign contributions would be subject to that same scrutiny. To sort of wall off that potential workaround. So if an individual acting as an agent is also acting as an employee or member of a law, architectural, engineer, consultant firm, or a similar entity or corporation, both the entity or corporation and the individual are considered agents. So I think it's just important as a general rule to think, okay, if you are somebody who's giving the money, if I want to give more than $250, I have to make sure that I'm going to comply with the Levine Act requirements. I'm going to disclose on the record. I'm going to, to be really mindful about that. And if you're an agency, you have to be really mindful of who is donating to your campaign, where they work, sort of why they're doing it. Are they attempting to influence the proceeding in any way? It can get complicated in practice, but it's also a pretty simple principle of, that this law is meant to stop pay for play. And so don't overcomplicate it. If you feel like some sort of influence like that is coming into your agency, it's just good to be mindful. Next slide, please. Okay. So this is good. So we have 4 examples here that my colleague Nick has written up in there. Great. So let's go through them. So a nonprofit focused on recreation has submitted an application to a Parks and Rec committee for an event permit that would allow the nonprofit to host a large fundraising and issue awareness event at the park. So the nonprofit is the applicant. They are a party to the proceeding. It does not have to be a person or a company. It can be a nonprofit as well. Okay. So going down next, that nonprofit has an employee who serves as its community outreach coordinator. In her capacity as an employee, she writes to the city's Parks and Rec director and appears at a meeting to express support for the application and how that event will benefit the city. So the outreach coordinator is an agent in the proceeding. Now, why is she an agent? Because she's employed by the nonprofit and receives a salary, some sort of wages for her job. Then she lobbies the city directly, right? She writes a letter and appears at a meeting in support of that permit application. So she hits the markers for an agent. Okay, next slide, please. All right, so another employee of the nonprofit is maybe just has a different role or is a little lower down on the totem pole, but still submits a public comment in their personal capacity because this is an important issue to them. They believe that the event will be beneficial to the community. Because that employee's source of income, the nonprofit, is the subject of the proceeding, that employee automatically has a financial interest in the proceeding itself. And so they qualify as a participant. Last one. At the same committee meeting, a city resident offers a public comment stating that while they agree that the issue is important, they think a different park located in a less residential neighborhood is a more appropriate venue. This resident explains that he lives directly across the street from where the event is proposed and that traffic would prevent him from hosting his weekly garage sale. Now here, the resident also qualifies as a participant in the proceeding because he opposes the permit application. He attends the meeting and attempts, and actively lobbies against it. And he has a direct financial stake in the decision because the city's determination would affect his weekly garage sale, and at least in his mind. Next slide, please. Okay, so I'm about to turn it over to my colleague, Nick. How is this $250 contribution calculated? The amount must be aggregated over a 12-month period to include contributions by the party and any of his or her or their, if it's a company, their agents, its agents, or a participant in any of his or her agents. So if I donate $250 and my agent donates $250, that is going to sorry, Ms. Leanne, we will get to questions. I am the world's worst multitasker. It's going to be, so you have to aggregate those. So that would be $500 in total, and we would be in violation potentially of the Levine Act if that was the case, depending on what we were doing. So it's not that I can donate $250 and all of my friends and family can also donate $250 if they're acting as agents on my behalf. Which obviously has its own analysis, but you get the point. And then we have a few examples here. Next slide, please. Okay, so I'll leave you here. There are some penalties for violating the Levine Act. If you do violate it, the FPPC may bring an enforcement action against you with penalties up to $5,000 per violation. Big deal. You could also be liable both civilly and criminally. I think that it's best, I think, to be better safe than sorry on this stuff. So if you think that you may be receiving donations, if you're an officer of an agency, if you think you may have received campaign contributions over $250 by somebody who could someday have or certainly within the next 12 months have a proceeding before your agency, I think it would behoove you to sort of do a full Levine Act analysis and talk to your counsel about what the proper next steps are. Anyway, thank you. And I will be available for any questions. And sorry I couldn't get to them all. But Nick, I'll turn it to you.
Thanks, Holland. And yes, we will get to questions at the end. So next slide, please. And then next slide. So after the legislature adopted AB 1439 in 2022, and it went into effect at the beginning of 2023, the FPPC a few months later in June adopted new and updated regulations that were necessary to provide definitions and clarify certain details about what the new Levine Act required. So I'm going to provide a brief overview of the regulations and how they help understand what the obligations are under the Levine Act. Next slide, please. So as Holland talked about a little bit earlier, a very key definition is when a proceeding becomes pending before the agency. So for officers, a proceeding is considered pending when the decision is before the officer for the officer's consideration. So for example, for a governing body, when the agenda is posted, at that point, certainly all of the members of the governing body should be aware that something is pending. I do want to clarify though, and this is the bullet point down there below, if a specific officer knows or has reason to know that the proceeding is pending before the jurisdiction of the agency, and it is reasonably foreseeable the decision will come before them in their decision-making capacity, it is considered pending as to them. So let me give you an example. Let's say that out of a 5-member city council, 4 of those members are not aware of a proceeding until an agenda is published. They're not aware of what the item is, who's applied for an item, or who the contracting party is, any of that until the agenda comes out. But let's say one of those council members is very active and proactive, and they have lunch with the city manager every week. If that council member finds out and knows ahead of time that an item has been submitted to the city, they're going to be considering this land use approval or contract that's coming up at the city council, the proceeding is considered pending as to that council member. Essentially, that council member is on notice that they need to be aware of not soliciting donations unlawfully under the Levine Act, or if they've received a donation, they may need their 30-day clock to return something might start to run if they want to participate in the proceeding. So there are particularities based on when someone actually learns that a proceeding is pending. It's not just when something is placed on an agenda or on somebody's desk for approval. So for parties, participants, or agents, a proceeding becomes pending once the item is before the agency for a decision or other action. So for example, once a party submits an application or submits a proposal in response to an RFP, it's considered pending as to them. And that makes sense. Of course, they should be aware that something is pending since they've submitted it to the agency. Next slide, please. The next regulation that the FPPC talked about, and as mentioned earlier, a lot of it has to do when a person knows or has reason to know about a financial interest. So while a proceeding is pending, and for 12 months after the decision, an officer knows or has reason to know that a participant has a financial interest in a proceeding, is prohibited from accepting, soliciting, or directing a contribution. So the definitions that the FPPC has come to will help us understand what this means. As also mentioned earlier, an officer is prohibited from taking part in the proceeding if in the past 12 months they have willingly or knowingly received a contribution exceeding that $250 from a party's agent, or a participant or a participant's agent, if the officer has reason to know of the participant's financial interests. So next slide, please. These will be the definitions that help us understand. Knows or has reason to know essentially means that they have actual knowledge of someone's financial interest, or the participant reveals facts during the proceeding that essentially lets the officer know that they have a financial interest that's apparent. An officer aware of any of the following facts, however, has reason to know of a participant's potential financial interest and may not take part in the proceeding if the official has received a disqualifying contribution from that participant or their agent. So these are items that if the officer knows about, they're definitely deemed to know about and basically shouldn't be asking for contributions from that person, or they might need to address past contributions they've received. So the participant has an interest in property within 500 feet of the real property at issue in the proceeding. The participant has an economic interest in a business entity that may see a significant increase or decrease in customers as a result of the proceeding, or the participant has a business relationship with the applicant that may result in additional services provided to the applicant. So there is a difference here between someone saying that they live within 500 feet of a property that's subject to a decision and just saying they live in a neighborhood. And we'll cover that a little bit on the next slide as well. Next slide, please. So under these regulations, an officer does not know or have reason to know of a participant's financial interest solely as a result of the participant identifying an interest located in the general vicinity of a business entity or real property at issue. So as in my example earlier, there's a difference between someone coming before the city council who's, let's say, donated $500 to all of the council members. There's a difference between that person coming up and saying, I live in the neighborhood and I really don't like this project, and someone who says, I live immediately next door to this project and I really don't like it, and it's going to diminish my property value, et cetera, et cetera. So it's a difficult distinction to be had, and does sort of require some on the ground decision making at meetings if someone's just becoming aware of something. But this is a distinction that the FPPC tried to make between someone who basically says they will be directly affected by something and it's very clear in the facts, versus I live in the general vicinity and it might affect me. And an officer may take part in a proceeding if there's clear and convincing evidence known by the officer that establishes it is not reasonably foreseeable the decision will have material financial effects on the participant's interests. I tried to think of a good example for this. Let's say something, the item before the council is for approval of a temporary sign that is non-intrusive, it's not large, but it's just sort of an odd sign that's temporary that we placed at a property for a few days. That might be a type of situation where there's not going to be a significant financial effect on the surrounding properties. So somebody who's coming there who's maybe lives next door, doesn't like it, it may not rise to the level of being actually material and having a material effect on their property. Next slide, please. So another key definition that the FPBC developed for the application of the Levine Act is when someone willfully or knowingly received a contribution. So an officer willfully or knowingly received a contribution when they have actual knowledge of the contribution has been disclosed by the party as required by the Levine Act. The party, participant, or another person has informed the officer of the contribution. The party or participant previously made two or more contributions of more than $250 to the officer, or the officer personally solicited or accepted the contribution. So next slide, please. So there might be situations where an officer is deemed essentially not to know about a contribution unless some of those items have happened that were on the previous slide. And the key thing on this slide that the FPPC has said that an officer who does not have actual knowledge of a contribution from a party or participant does not have reason to know about it solely based on the fact that it was reported on their campaign finance disclosure report. So merely being reported on their report, an officer may not know that they actually received a contribution from someone of over $250. But it can be a very difficult factual situation to parse. And so I would encourage agencies and their officers to be aware of what contributions were received. And let me just clarify, I would encourage officers to know about their contributions that were received. I think there could be very difficult factual situations where There are facts suggesting that the officer maybe should have known about a contribution that was received in the past, and they may say they didn't know. And that's something that you don't want to be in the position of telling the FPPC that you didn't know about a contribution and trying to really prove that case or that situation in a proceeding for a potential fine or even worse, a criminal violation. Next slide, please. Holland talked a little bit about returning contributions. So contribution under the regulations that the FPPC has put out interpreting the Levine Act, an officer may return a contribution if it is received from a party prior to the officer knowing or having reason to know that the proceeding involving the party had commenced, and may return a contribution from a participant prior to the officer knowing or having reason to know that the participant had a financial interest in a proceeding. So, for example, an officer may receive a contribution from someone who lives in a neighborhood who doesn't like a project. They may learn later that that person lives immediately next door to that project, would be heavily impacted by it. At that point, their potential 30-day clock to return that contribution, if they want to participate, starts to run. So it has to be returned within 30 days from the time the officer knows or should have known about the contribution and the proceeding. Next slide, please. So the FPPC's regulations also laid out ways that officers could participate in a proceeding prior to returning a contribution. So let's say the officer finds out at the council meeting that someone who is coming up and speaking against a project has a financial interest in the proceeding. This is the first time they've learned about it. They know they received a $500 contribution from that person, and they still want to be able to participate in the proceeding. So they can take part in the proceeding before returning the contribution if the decision is made at a public meeting of the governing body or board. The officer has known or should have known about the contribution or proceeding for fewer than 30 days. And after learning of the contribution or proceeding, and before taking part in any further discussion or consideration, the officer discloses that contribution on the record, confirms that it will be returned within 30 days after they knew or should have known about the contribution, and then actually returns the contribution within that time frame. So this is a little bit of like the last minute situation where the officer legitimately just finds out about something, either the contribution or the proceeding or the financial interest there at the meeting or shortly before the meeting, and they still want to participate. There's a process to do that under the regulations that the FPPC has put out. Next slide, please. I think we might have, oh, sorry, no, sorry, next slide. I thought we went too far. Let's see. So a party's obligation to disclose contributions. This is the final regulation that the FPPC put out on this. On the date a party to a proceeding files an application or other request that initiates a proceeding, the party must disclose the amount of any contributions they've made within the past 12 months and the names of the contributors. So this is an obligation on the party that's initiating a proceeding. And this might be one of the reasons that agencies might, on their RFP responses or on their land use entitlement applications, things like that, include a specific text that asks parties to make these disclosures, at least prompt them to think about it and make the disclosures ahead of time. Again, it's an obligation that is on the party, but because there is an intertie with what the officer's obligations might eventually be, it's very helpful to try and prompt the parties to make these disclosures at the time that they're supposed to do so when they submit the application or initiate the proceeding. For a contribution made during any stage of the proceeding, the party must disclose the contribution within 30 days of making the contribution or on the date on which the party makes its first appearance before or communication with the agency regarding the contribution, whichever is earliest. And then contributions from a party or participant are aggregated, as Holland mentioned, with contributions of their agents. Next slide, please. So we did want to note there was a legal challenge to AB 1439 after it was it went into effect in 2023, but it was thrown out by the court. So it was dismissed on June 16th of last year and the deadline to file an appeal has passed, we're not aware of any current legal challenges to this expanded version of the Levine Act. Next slide, please. That said, there is pending legislation that would make some changes and that relate to the Levine Act. AB 2911, a pending bill, would raise the $250 threshold to $1,500. There is a somewhat similar bill in the Senate, that's SB 1243. That would narrow the application of this expanded version of the Levine Act. It would only apply to contributions of over $1,000. It would change some of the time periods, shorten them in certain ways, lengthen others, lengthen the time of return, I believe, but shorten the overall 12-month time period. And then it would exempt housing developments from the definition of applicable proceedings. And then finally, SB 1181 would require information about the Levine Act disclosure to be included on agendas and prompt the parties to make these disclosures. So again, this is all pending legislation. We don't know how far these bills are going to go this legislative session. Right now, as far as we know, the Levine Act is what it is through the end of at least 2024 and through this election cycle. But these are things that you might want to be aware of, or bills that you might want to track or keep in mind if they do eventually pass. Next slide, please. So best practices and some outstanding issues. Next slide. So as I talked about, one thing that agencies may want to do is revise application forms and RFPs to require applicants and proposers to disclose any contributions made to officers or candidates when they submit the application, so that the agency is already aware of those and the officers can be made immediately aware, and to help, like I said, prompt those parties to make the required disclosure under the law. Another possibility is adding a standing agenda item reminding officers to disclose contributions. This could either be just language, general language on the agenda, or an actual agenda item that is intended to make those disclosures. Some agencies have things like this on their agendas already. A lot of agencies don't, but that might be something to consider depending on your agency, depending on how frequently conflicts that arise out of the Levine Act might arise for your particular agency. And then, of course, providing training to officers. That is a really key aspect of this, to make sure that people are aware of what their obligations are and what the potential consequences are for violation. Again, as Holland talked about, violations of the Levine Act are on the officer and the parties and the participants. They're not on the agency. There is individual responsibility for the officers that's involved. But of course, like a lot of Political Reform Act issues, the agency is also intimately involved in sometimes figuring out if there's a conflict. Agency counsel is consulted to see if there's a conflict and someone needs to recuse, those types of things. So there is a level of involvement from the agency and agency counsel and working with the officers, but ultimately if there's a violation, it is on the officer and not on the agency. Next slide, please. Some outstanding issues that remain unclear are proceedings that take place or arise out of a closed session item. So for example, if a settlement agreement with a party who has contributed to a council member is being discussed in closed session, what is the process for the council member disclosing their contributions and recusing themselves? That's not something so far that the FPPC regulations expressly address in this context. There are FPPC regulations about what happens if it's a normal, let's say a normal financial conflict of interest. Let's say that a council member has a financial interest in a party, the other party to a settlement agreement. There are processes that the FPPC has laid out for how they would recuse, a council member would recuse in that normal type of situation, but not under this Levine Act type of situation. So that's an area that still needs to develop a little bit. And then another area that occurred to us that is an outstanding issue is change orders to competitively bid contracts. Competitively bid contracts themselves are exempt from the Levine Act requirements, but there is, because there's some discretion involved when a change order comes up, it's unclear whether change orders would be considered a proceeding and someone might need to recuse themselves if the contractor or involved parties have made donations to council members or board members or other candidates. And I know that we're running short on time and I do want to be able to get to some questions, but I do want to run down a list real quick of a few items that the FPPC has addressed in advice letters. And I'm happy to work with Melissa to add a slide on this with these advice letters that I'm going to run through real quick. So the FPPC has said that the Levine Act does apply to contributions to candidates for a political party's county central committee. This is something that I understand a lot of elected officials are more commonly doing as they run for office and hold office. They also run for either the Democratic or Republican or other parties' county central committee that is an elected position that's on the ballot, but ultimately it's a party committee. Contributions to those campaigns for party committees can cause Levine Act conflicts of interest. So officers need to be aware of that if they're running for a county central committee. It also applies to proceedings for small contracts like purchase orders. So let's say you have a situation where your director of public works is also running for assembly, and that person is receiving campaign contributions for assembly, and they get a purchase order that comes to them to sign off on, and it's from someone who has donated more than $250 in their assembly campaign. They are considered an officer of the agency. They have the ability to make the decision on the purchase order, and they've received a violation or a contribution that is in excess of the amount under the Levine Act. That person might need to disclose and recuse themselves from participating in that the approval of that purchase order. So small contracts can be included. In strong mayor systems, a strong mayor may participate in a proceeding due to necessity, but can still not solicit, direct, or receive prohibited contributions. So for example, if a land use permit is going through a city council process and there's a strong mayor system where the mayor has the opportunity to approve or veto an action of the council, the mayor can still take that approval or veto action, even if the Levine Act typically would prohibit it, but the strong mayor can still not go out and solicit, direct, or receive prohibited contributions from the other party in that situation. And then finally, there is the FPPC has said that competitively bid contracts for the sale of property are also exempt under the competitive bidding exemption to the Levine Act. Next slide, please. I'm going to leave this slide in here, but I'm not going to talk about it so that we can get to some questions. These are just other election year reminders for you about behested payments, prohibition on expenditure of public funds or resources for against ballot measures, and then mass mailing at public expenses, which have slightly different rules when you're within 60 days of an election. So I'll leave that for when the PowerPoint is disseminated if you want to look into this further, but we wanted to remind you of those. And Melissa, why don't we jump into questions with a few minutes left?
Yeah, perfect. Thank you so much. So we will make sure to get the slides out to you so you can see all of those additional reminders as well as the letters that Nick just mentioned. We'll send all of that in the follow-up so you have access to that. And we do have quite a few questions, and I know unfortunately we won't be able to get to them all, so I've got contact information on the screen for you, but we will get to as many as we can. So I'm going to start with, so this is something you touched on a little bit in regards to housing and land use decisions, but can you talk a little bit more how this would apply to land use decisions and if or how it's different than normal recusal processes?
So, yes, it definitely does apply to land use decisions when they relate to specific properties. If it's a general zoning rule that is generally applicable across a city or a jurisdiction, or affects multiple multiple properties like an entire neighborhood or a specific plan or something like that, it may not rise to the level of being a proceeding that's subject to the Levine Act, but it does apply if there are particular properties at issue, especially if it's like initiated by another party, like a zoning change or a conditional use permit. And then recusal process is pretty much the same as we're used to under the Political Reform Act. So the official will disclose what the conflict is, or in this case, what contributions they received in excess of $250, step down from the dais and leave the room.
Perfect, thank you. This is something you were just mentioning a little bit as well, but I'm wondering if you can expand on any recommendations on if agencies should include language in contracts that address compliance with this legislation. So you talked about including information on agendas and things like that, but is there any
I think it makes less
rule of
sense.
thumb there?
Yeah.
I think it makes less sense including it in a contract than it does in the RFP or application process, because once the contract is made, essentially the action's already been taken, and you're sort of past the point of no return or whatever whatever term you want to use. It's better to have something earlier in the process that prompts, probably, rather than in the contract itself. But might not be a bad idea to mention it.
Are you aware of any sample language that we could share with folks to include in RFPs or solicitations? Does the FPC have anything?
I haven't seen any yet, and I haven't seen any models coming out of the FPPC. But that does remind me, I do want to put in a plug. The FPPC has some very helpful guides they're titled as essentially the Levine Act assistance for officers and Levine Act assistance for parties, participants, and agents. And they're essentially resources that are tailored to those particular audiences. So those are very, very helpful. But I have not seen specific language that I would point out or recommend yet.
Yeah, it may make sense just to have a section where someone submitting an RFP could say, where the agency could just invite them to just be forthright and say, well, I donated this to this officer, to their campaign or something like that, so that it's all out in the open. But I think that ultimately, going back to Nick's point about individual responsibility, it's going to be between them and the FPPC, or them and the, everybody involved has to bear the responsibility on their own and be responsible for tracking all that stuff. So I don't think it's necessary, but it could start to be a best practice thing as sort of agencies adapt to a new world where, for a lot of time, counties and cities have not had to do this, or special districts, they haven't had to deal with this. And campaign contributions haven't they were under the PRA, they weren't considered income that rose to the level where you had to recuse, and they were, and they gave rise to a conflict. So it's a new world. And so I think that just as best practices sort of evolve, especially this year in an election year, we'll certainly, be around to share those helpful tips and stuff in the future.
Perfect. I want to see if we can get to one or two more quickly, because there's quite a few in this next theme. So Holland, I think I heard you just answer this question, and I think I saw it in the deck as well. But just to clarify, the onus and the requirement is on the officer themselves, correct? Not on the agency, to make sure that they're tracking and disclosing all of this. Is that correct?
Right, correct. Yeah, and on the party and participant and agent. Yeah, it's on the individual or corporation. There's Nick, I think you touched on this, but like if a corporation or a company is submitting or is participating or is a party to a proceeding, the onus also lies with the company as well as its chief officer or whoever's acting in a decision-making role there. So, so a CEO or maybe a chief development officer or something donates to a council person's campaign, they are also considered a party or participant, or where I guess, probably participant in that back scenario. So it's important, I think, that we sort of just, adapt, right, to a new role, in that we need to really track what's coming in, who these folks are connected to, because it doesn't matter, if you knew or should have known that they were connected to a proceeding, then I think that, that I don't know if the FPPC will really buy an argument of, I just didn't know, we all kind of have to know, and we have to do a really good job about being careful now, if we want to comply with this law, which obviously.
And in terms of whose responsibility it is, as you summarized, Melissa, and as we've said, it is the responsibility of officers, because that is who the FPPC or a DA would pursue for violations. With that in mind, or with that said, there will be a spectrum of how agencies handle this. Some where it is completely on the onus of the officer to figure out everything, the contributions, the who the parties to an item are, who the participants might be, things like that. There may be agencies that take a moderate role where there's a more active soliciting and disclosing to their officers. We received an application for a land use approval. These are the parties, these are the contributions they've made. You as an officer should be aware of it. And then there's sort of a more extreme, and I don't necessarily want to endorse this sort of extreme version, because what I've heard is that there are some agencies where the officers, for example, board members or council members, are placing real pressure on the agency staff to monitor the campaign contributions, essentially. And I think that, and to let them know when they see violations from the campaign contributions. And I think that in that context, that type of approach might go too far. Some agencies might choose to allow that or to pursue that, but essentially there are, in my view, those would kind of be encroaching on using agency staff in ways that are more related to the campaign than related to what is the agency side of the responsibility. The agency side of the responsibility is to be aware of the applications, the parties, the participants that they know about, et cetera, and not the sort of campaign heavy side. The other reason for that rationale or that thinking on my part is that this law applies to federal, state, and local campaigns. So you might have a city council member who is running for Congress, and I don't think we would expect a city clerk to be parsing through congressional campaign finance disclosure to figure out if their council member has a Levine Act conflict. It's sort of beyond the scope of what the agency's responsibilities are. At least that would probably be my view. But I do think there's likely to be a wide spectrum, especially probably for these first few years, if this law remains in place, of what responsibilities are.
Perfect. Let me ask one just final question related to the response you just gave. Is there any advice or tips or best practices that you've started to see emerge for the staff that are online, for the clerks or the executive officers, or folks that are on that side of the fence, that are on the line, on how to help their elected and appointed officials navigate this? You know, is it training? Is it, you know, adding to the agendas, as you've mentioned? Any other tips that you can share on how to help the staff navigate this?
Training, yeah, is the top one. And then I think, Melissa, I think adding something on the agenda just so that folks can remember to, you know, I mean, everybody, I'm sure all the officers that are on this call, or, you know, attorneys, you know, everybody's so busy. You have tons of stuff to think about. You know, I think that it's really critical that this kind of just becomes part and parcel of how we do our jobs. You know, is that, you know, you get a campaign contribution, you're constantly checking, you know, what's kind of coming through your city or county or district against who's giving you money, who's coming to your door. I mean, because I think to Nick's point about relying on your staff, on your agency staff, even, you know, to sort of do this job for you, I think leaving aside probably the how that is probably improper just on its face, it's also, I don't think that I relied on my staff and they messed up and therefore I violated the Levine Act. I don't think that that would fly with the FPPC or the district attorney. So I think that it's really critical for officers that we, and for their counsel, so for me and Nick and for other attorneys like us, that we kind of get used to, you know, to a new world in which this kind of just becomes how we do things. And that we're constantly sort of just checking and making sure that we're keeping everything above board.
And the other benefit of training, I think to your point, Melissa, is expectation setting for the officers, that they don't have an expectation that the agency will let me know whenever there's an issue, and to not have a situation that gets out of hand, where someone's violated and thought that agency staff was doing something or should have been doing something. So training can be an important opportunity to level set and make sure that everybody is on the same page in terms of expectations.
Perfect. And I will just give another quick plug for the FPPC and their advice letters and things like that too. They can always be a great resource to help navigate some of these questions as they arise. So we are a couple minutes over, so I'm just going to go ahead and quickly close this out. Just another plug for ILG. We may be doing additional resources or training in this space, and definitely with the election year upon us, thinking about that very top of mind as we think about additional webinars and training offerings. So connect with us on social media, sign up for our newsletter is a great way to keep it on top of some of those things as we release them. Reminder that we will be sharing the recording and the slide deck, as well as some of the additional materials that have been mentioned during today's conversation as follow-up. So keep an eye out for that. And sharing contact information one more time. Again, apologies that we weren't able to get through all of the really great questions that came in ahead of time and during today's webinar live. We know there's still a lot of interest, a lot of questions in this space. So if you need if you have additional questions, please reach out and we will share additional content as we have it. Holland or Nick, any final thoughts or comments before we close out?
No, just thank you all for attending. I know that this is a really tough and dense topic. Please consult your agency counsel, talk to the FPPC if you need advice. There will be a lot of that this year.
And if any of you will be at Aqua in Sacramento next week, come to Nick and I's presentation on Thursday morning. We will be presenting with the general counsel for the FPPC. A lot of it will probably be something you heard today, but maybe yeah, we'll have some new stuff there too. So a little plug for Aqua. So yeah,
any water districts on the line, hopefully.
Yeah, true. All right. Thank you.
All right. Well, thank you all for joining us over your lunch to learn a little bit more about this. And Nick, Holland, thank you so much for your presentation today and your continued partnership. We really appreciate your expertise and you sharing that with us this afternoon.
You bet.
Thank you.
Anytime. Thank you, Melissa. Thank you, Nikita. Appreciate it.